Hey everybody, good morning. We're live. I'm JD Houvener, and I'm the owner here at Bold Patents Law Firm, and you made it to the Bold Today show. We're here every Wednesday at 9 a.m. Pacific and noon on the East Coast. I'm looking actually on camera. We got some of my pictures up on my kids' art coming up on camera. I didn't realize that. So all good, right? Hopefully all the kids out there fully understands. They need to relate some of that. So anyway, what I want to do is share with you a cool topic today on office actions. Okay, office actions are when the examiner at the USPTO rejects your application for patents. And I'm going to have our co-host, Matt Colseth, come on in just a few minutes, and he's going to share what happens on the trademark side when you get a trademark application rejected and go through kind of the different types of rejections. Help you kind of breathe easier. Maybe you've been through this before and know that rejection isn't final. Okay, it isn't a denial. It is just meaning that some part of the application didn't meet the snuff, right? It needs to get back in, get resubmitted, and so you can actually get that application all the way through to grant. Know that the examiner, right, it's their job is to make sure that nothing gets through that shouldn't. Okay, so they're motivated, incentivized rather, to reject. Okay, if when in doubt, they're going to reject it, and it's their job to find any kind of prior art or reference that's close enough to what you've invented, or on the trademark side, close enough to similar enough to the mark that they're going to reject it, right? And so it's your patent attorney, your trademark attorney's job to find out what it is that you've come up with, form some argument, change or make amendments, and then move forward. So again, I'm JD Houvener. For those of you that joined in late, and I'm the owner here at Bold Patents Law Firm, and we're here every week doing a live Q&A, and I'll be taking live questions first and foremost, and we'll be having a discussion about office actions on the patent side and the trademark side, and then we'll do the Q&A that we've already gotten preloaded over the week from our AVO community. I've got 3 patent questions, and we'll try to get to about 3 or 4 trademark questions as well as time allows. So a quick little disclaimer here, that while we are attorneys, this is not meant to be legal advice for you specifically. Okay, this is a live broadcast for the public audience. So please don't share any of your confidential information or invention details here. If you do feel like you're ready to move forward, you want to engage with our firm, the best way to do that is going to be starting with a screening session, right? We're going to actually do a little interview to see if you're a good fit. And you should be doing the same for us, right? See if we're a good fit for you. Okay, so to take action, follow this link right here. And again, it's a screening session. Okay, so it's 15 minutes, just information. You get asked questions about who we are as patent attorneys, as trademark attorneys, what our firm is all about. See if it's the type of service that you're looking for. And in the same way, we're going to make sure that your area of need is something that we can solve. And if it's not, we'll refer you off to somebody else. Okay, so click that link, and for taking action, I'm going to give you a copy of this book right up here, Bold Ideas, The Inventor's Guide to Patents. That's a quick tutorial. It's about an hour and a half long read. Gives you all the nuts and bolts on what patents are all about. Trademarks, copyrights, and trade secrets, also all those sort of things. So take action, schedule one of those screening sessions today. So let's get into it. The topic of the discussion today is rejection. Rejection. And for some of you who may not be familiar, when you try to get a patent, right, when you have an invention, you don't just send it off to the patent office and then they automatically send you a certificate that, hey, you've invented this, awesome, we love you, here's your 20-year patent. No, you actually have to convince an examiner, right? So these examiners have been through at least a Bachelor of Science degree, graduate level degree. They have expertise in one specific field, okay? And it's the field that you've invented it. So when you submit your application, they will get itemized. They will get basically categorized into what's called an art unit. Okay, so if you're inventing in mechanical devices, it's going to be going into that field. And within that, maybe you've got some electrical aspects to it. Maybe it's a wheel or it's generating power. Okay, now it's a power axle mechanical field, right? So that will go to a specific art unit, an examiner, that they look at those applications all day, every day. So they're very familiar with the state of the art of electromechanical, wheeled motion, mechanical engineering inventions. So they know about the publications in the field. They know as much as a company or an individual who might be in that industry, and they're going to know about all the publications and the patents that have been issued, and of course that have been published through the patent office. So they are very knowledgeable. All right. So once your application gets submitted, it's their job is to do their own patent search, okay, and then examine the claims to see if it is actually new, to see if what you've invented is the first of its kind in all of the knowledge in the world. Okay, that's a big job for the examiner to do. And so, as you can imagine, their job is going to be looking at every single word of that claim language to see if anything has come up before, like it. Okay, so looking across design, utility applications, and anything that's available on the internet, right, on print form, in a library somewhere that's available to someone in the industry. Okay, and once they get that examination done, it's almost always true, and it's around 90%. They're going to find something wrong with the application, or maybe the claim set is asking a little bit too much. The inventor is saying they've invented all of this space when really they've only invented this much, and so they're going to reject that claim. Or maybe the drawings, right? They're not actually done per all the rules, and the lines aren't connected. The figures don't match with the specification. Different rules with respect to the written description where it's not fully enabled, right? Maybe they've not described some part of what's being claimed. Lots of little things can happen, and the application can get rejected. All right. So when you get that rejection, know that you're among a lot of people, right? So 90% of the time, an application will get rejected. And so the first rejection on the patent side is called a non-final rejection, meaning it's, you're guaranteed at least one more shot at it. And before you respond quickly or emotionally, it's always best to get professional advice on how to respond and whether to actually concede a little ground or not. Right? There's many times where the examiner says, "Well, your claim is too broad. There's 3 or 4 references that have already shown that this has already been done before." And it's easy for an inventor to get sort of deflated and everybody think, "Oh gosh, I'm dead in the water." When really all they have to do is maybe make a few changes to the wording. So they kind of just subtly narrow the claims a little bit, focus the examiner's attention on what it's doing functionally, and they'll get allowed. So working with a patent attorney that is familiar with what an examiner is looking at is crucial. So let's say you respond, right, in your best efforts. The next thing that can happen is you can get a final rejection, right? Which sounds ultimately damning, right? Really bad. Like, this is the end. I spent all this money, effort trying to invent and get this patent, and now I'm final rejected. This has got to be the end, right? No, it just means it's the second round. Okay, it just means the examiner has looked at it and said, well, for the same reasons I rejected it before, I'm rejecting it again. And it's just they're sort of digging their heels in, okay? And it sometimes merits following up that from with an interview, right? Talk with the examiner about as a person, where are they at? How are they reading the actual words that you're writing? Where are they coming from? Perhaps even emotionally, or were there references, how they're interpreting certain language that you're writing in your arguments. And what you can do is simply pay an additional fee and start over, right? Resubmit the application. It's called a RCE, a request for continued examination. And an RCE will allow you a full new, at least 2 more reviews to get at least another non-final and then perhaps another final office action rejection. So this can go on a long time until you kind of get to the point to where either you know you're going to get it allowed and you can concede some ground, or the rare case of where you're saying, it may not be worth pursuing. Maybe the market opportunity isn't quite as broad, and you want to pursue another invention. Okay, so that's kind of the way the patent track goes, and the differences between a non-final and a final. So any questions there, please keep those coming in the comments. I don't see any live questions at this point. What I do want to do is invite my co-host, Matt Colseth. Matt, are you there?
Yeah.
Hey, Matt, good morning. Thanks for coming on.
Yeah, thanks for having me.
Absolutely. So, this was teed up as a patent discussion, rejections from the patent office. But I'm like, you know what? There are examiners on the trademark side too. So, I wanted to hear your take on it, just kind of general. What do you see? How often do you see rejections? Rejections, right?
Yeah, no, I mean, these are all good questions. And, I think that we, do a good job of anticipating potential issues at the USPTO before they happen. I think that's what a good trademark or patent attorney can do, is just, kind of look into the future a little bit and say, this is where I see us being vulnerable to an office action, and hopefully, get ahead of it. That being said, they do happen. They can happen to clients who are, represented by counsel or not. Sometimes they're silly issues. Maybe the client's applied for a trademark application and has a misspelling, or the legal entity isn't, flushed out in the application itself. Those are easy things to fix. But obviously, there's office actions that get more complicated, right? And that's where having an attorney who's got some experience and kind of can lay out the strategy and kind of the way forward makes a lot of sense. In terms of how frequent they are, I guess I have a hard time kind of gauging that. I guess I would say it's probably around 15 to 20%. I would guess from my own experience.
Okay.
Those office actions, I can tell you from a statistics standpoint that if they're a substantive office action, meaning a major office action, your statistical chances of getting over the office action are going to be about 1 in 3, right? So you want to avoid those major office actions when you can, because your odds of getting over them are not great. So, yeah.
That's pretty interesting. I didn't know that. So, so basically, in a summary, you're only going to see a rejection on the trademark side, let's say 20% of the time. It's really the opposite for patents. I do think you're going to see a rejection 80% of the time. Like I said, 90% for patent. And then it's also sort of the opposite. That if you get a rejection on the patent side, I think it's fair to say 2/3, or 67% of the time to be successful. So it's really kind of fascinating to know that.
Yeah, I would say in the general population too. I mean, obviously, most trademarks that are filed in the United States are filed by individuals, right? They're not filed by necessarily attorneys. So the rejection rate is obviously going to be much higher if you're unrepresented, or even if you're not a very experienced trademark attorney. I mean, I imagine your rejection rate is going to be a lot higher. I would think ours is around 20%. I've never actually looked at it, but that feels about right to me. We try our best to avoid those office actions because, one, they slow the process down for the client. They cost time and efficiency, right? And
yeah. No, I think that's perfect. I love how you started that with, working with an attorney. You're going to know what you're getting into when you start.
Right.
Right up top, you're wearing my, patent research, right? Just like you do trademark research, before filing. We do from our clients, and we do kind of know, well, this is going to be a little risky, right? You kind of know it's going to be a battle. So in that sense, it's going to be tough. And as long as you're setting expectations with the client.
Yeah. I mean, I can tell you that just this morning I was talking to a couple clients who have a couple tricky trademark issues, right? They want to register, but for various reasons, the path to registration isn't clear, right? But yet we want to register the trademark. So what are we going to do? Well, we have to come up with a really good plan for how we're going to avoid that office action at the USPTO. Because as soon as we get that examining attorney's attention at the USPTO, they're going to pick through the application. So what are we going to do to increase our odds of registration and avoid those potential pitfalls before they even occur?
Cool, man. Yeah, one thing I want to mention, I won't take too much longer on this, but one thing I've always been jealous of in many ways, on the patent side, the examiners, they're scientists, they're engineers, right? They have that degree, but they're not attorneys. And very rarely attorneys. And on the trademark side, right, they're attorneys. And so tell me, do you generally get, obviously I haven't worked on the patent side, but I would imagine you're going to get more appreciation of legal arguments, and maybe just a bit less back and forth, maybe?
It's interesting working with examining attorneys, and I don't know how many there are at this point in the United States. I imagine it's in the hundreds. But you do this for a decade plus, and you kind of get to know some of the folks that you're working with, right? And you see their name, and you're like, okay, I know their personality type. I know that they're going to want me to call them, right, and talk through this office action before I even respond. But yeah, it is fun in the sense that you're working with legal professionals, attorneys, who for the most part take their job very seriously, right? And they are very interested in the nuances of trademark law and good argumentation and well documented briefs, and it's fun. Yeah.
Cool. Right on. Well, let's jump into some Q&A from the Avil community. We've got 15 minutes left here. We got 3 patent questions. We'll kind of go back and forth just to keep it interesting here. Any of those live viewers have questions, throw them in the comments. We'll jump on those right away. So this one here is out of New York, New York. And it's got to do with math. This is, oh no, math. Uh-oh. Okay.
I went to law school, so we didn't have to do math.
What's that? Okay. So can a person patent a math formula or method of calculating for a specific purpose or no specific purpose? If yes, can someone just change the formula slightly to bypass it and call it their own despite what they've not figured out? Well, okay, so a formula on its own, okay, a formula itself is likely not going to be patent eligible, okay? The issue there is it's not functional, okay? So patents have to fit into the three major buckets of utility, design, or plant, okay? And a utility patent, which I would imagine this would be for, a formula or a series of, equations. It's like a truth, right? It's a statement of how inputs and outputs go, but it doesn't actually relate to something tangible, something you can describe in the real world. So I would guess very likely you could move from an equation to a functional description, right? Where it's actually doing something in real life. What are those inputs and outputs of the equation? Let's talk about those. And then is that solving a problem in a unique and novel way? So you're close. When you're talking about equations and mathematical algorithms, that may be, but what's behind the scenes in terms of what the initial spark was to the creativity. But in order to become an invention, an eligible invention must show functionality. It has to have definiteness, structure, and have to have a descriptor so that someone else could go out there and build it, make it, and have it be useful, right? A formula on its own isn't useful, okay? In other words, it's not providing a real benefit to anyone. It's just a statement, right? It's perhaps even a law of nature, if it's like one of those E equals MC squares type of an equation. All right, I hope that helps you out. Now, your second part of the question about a method, right? A method of calculating. Absolutely. Okay, that's a series of steps, right? Steps 1 through 4, so 1 through 10. And the question is, are those steps, performing all of the steps in that order, is that the first time anyone's ever done it that way? Okay, that's the novelty check. And then is it actually providing a utility? Is it providing a benefit above and beyond what you could have done if you didn't follow those steps? So thank you for that question. Let's jump in on the trademark side. Seems to always be more trademark questions. We have 8 of these. We'll see how many we can get to. This is out of your home state of Minneapolis.
All right.
Minnesota here. Looks like a pretty beefy question too.
We're very, very intelligent in Minnesota.
Absolutely. Here we go.
Good public schools.
Got to do with pasta too. I love it. A food question. Okay. You want to reapply for a rejected trademark. This is perfect on subject. In classification categories, excluding the single line that was originally rejected. So can they reapply? They had a trademark application for one product line rejected 2 years ago because of phonetic similarity to another product. We now have developed several lines in different classes. So dates, spices, rice, tuna. How successful would a reapplication for the brand trademark be, delisting the pasta as one of our lines?
Ooh, really, really good question, right? And this gets back, so the larger question is, how related are these goods and services, right? And obviously this is a product question. So for the listeners at home or in the office, there's 45 classes of goods and services at the USPTO. Foodstuffs covers a number of different categories. The USPTO generally views those categories as highly related, right? Because typically they're going to come from the same distributor potentially. They're going to be found in the same grocery store, albeit different aisles. And so those arguments get kind of nuanced in terms of whether or not consumers can reasonably expect those products to travel in the same channels of commerce. So it gets complicated. Now, if the office action originally said specifically that this particular product was the reason why the whole application was being rejected, you got a pretty good chance of being able to convince the next examiner of that being the case, and relying on that previous communication. That being said, I'd be curious why the applicant didn't, remove or narrow that particular application claim during the application process. And there might be a reason why. So, yeah, what I would say is, if the viewer is interested, give me a call, send me an email, and I'd be happy to kind of talk them through it a little bit more. I'm curious now.
Absolutely, me too. Yeah. So you're saying it's possible for, even within that foods that class, that large class of food,
Yep.
to specify, and to say, well, we're doing everything but pasta.
Right.
That's
Yeah,
pasta.
exactly. And the examiner might go for that. And, oftentimes we can convince an examiner, that pasta is not the same as rice, it's a different kind of food. I mean, there's good argumentation there. And sometimes it comes down to the examining attorney and the argument that you put to them.
Awesome. Matt, what is your email address real quick?
Sure. It's Matt, MATT Kulseth, KULS as in Sam, ETH at boldip.com.
Okay, perfect. I'll put that in.
Good Minnesota Norwegian last name.
Absolutely. Well, that was a good question out of Minnesota, your home state too. So you definitely back that up. Okay, let's do one more. Let's go back to the patent side here. Take a breather on that. That was a good one. Again, this is patent application. Is the category. This is out of LA, Los Angeles, California. A nice short question for me. I like this. Okay. It's easy, right? That's the thing. All right. So this is about public domain question. Can I legally publish a public domain patent? I'm writing a book on inventions. Can I be sued if I publish content from public domain patents? Okay. Well, let's take a couple things to think about here. Okay. I like to be real transparent. I don't know what a public domain patent is. Okay. To me, if information, right, an invention is published to the public domain, meaning you're just sharing your invention, I think that's what's meant by the question asker here. And in that sense, the inventor is not, pursuing commercial interests. In other words, they just want to give and share their knowledge. And so they just publish their inventions. Instead of sending it to the patent office to try to get a patent, they have given up their information. They've just made a publication. The other thing that a public domain patent could be is someone has actually gone through, spent money, invested time, gotten a true patent, and then said, you know what? I'm going to give it to the whole world for free. I'm not going to charge or go after you and be a troll and try to, pursue an infringement action against you. So giving it up, I don't really know what that term means, but it could mean one of those two things. So I want to start with that. Okay, so you're writing a book about that. If there's some sort of a body that designates patents for a public domain patent, meaning someone has said, yeah, I'm giving this away. I'm waiving all my rights to be able to enforce this patent against anyone from the public. So if that's true, and you can confirm that, right, then you can make, use, and sell that invention. Okay. You'd also want to make sure, right, on the copyright side, that they've waived all rights to their writings. Okay, so there's two separate pieces of IP happening. There's the invention, which let's assume that they're given away, right? They're not going to stop anyone from making, using, or selling that invention. But maybe they're still holding on to the writing, the actual description, whatever, how they articulated their invention, and just like they would any other piece of writing or creative work. So you want to double check, right? As an attorney, you got to be as in a way cautious as possible, give you the best advice, and that's going to be to make sure that you have the ability to make, use, and sell the patent, and then also make sure you have the copyright that you can reproduce the work, the actual writings of the application for your book. If someone's already given it to the public domain, it's highly likely you can just reach out to that inventor, contact them to try to just get their permission to use it in your book. I think at the very least you should give attribution to the inventor itself, and if there's if you're unable to get hold of the inventor, you can try to contact any attorney that also was on that application or a representative of that company. So that helps a lot. Charles Reeves, good to see you. Thanks for joining. Thanks for that question. Matt, would you add anything to that? I mean, anything on your mind as you're going through that?
No, I think you answered it beautifully. Yeah, I'm not really sure what a public domain patent is, but I think everything you're mentioning, especially regarding the copyright and how that particular invention is being described, you don't want to, copy paste wholesale.
Right. Yeah, I mean, honestly, who would go through the efforts of trying to get a patent and then just give it away? That's That's quite generous, quite philanthropic.
Yeah, I'm almost wondering if they meant just public domain, meaning like published, right?
Yeah.
Google patents kind of thing.
Absolutely.
Yeah.
Okay, let's do another trademark question for you. Um, and that might take us to the end. I did see we had one other live viewer. So yeah, if you have any questions, fire those in right now. We'll get to that before the end of our time today. Okay, this one is, so you can pick, Matt. You want to go Las Vegas or New York?
Ooh, let's go warmer. Let's go Vegas.
Let's go Vegas. All right. So here's this one. This is got some cool example language too.
Sure.
I may not be able to go read it all because it's a little bit long, but it's got to do with this, with the word peachy and blitzy babies. So I'll get that. How strict is a trademark? I understand that while naming a new business, completely avoiding anything that is trademarked is the only way to do anything. However, how strict is it? I'm confused on specific words like colors or adjectives. What if I wanted to name my business Peachy Plushy, but the word peachy is trademarked? Yet there are thousands of other businesses with the word peachy included in their trademark as well. I'm not able to use the word peachy at all? Or for example, if I wanted to name my business Blitzy Babies, the word blitzy is trademarked on its own in a completely different industry. Am I not able to use it with a trademark word, even if I'm putting something else with it? Thank you in advance.
Great question, right? And this kind of harkens back to those 45 classes of goods and services I was talking about earlier, right? For the most part, the USPTO is going to say that these 45 classes are potentially distinct from themselves. And so if you have a registration or somebody else's registration for peachy in the apparel class, it's not going to impact your ability to sell furniture, for example, right? Using the word peachy. So it all kind of goes back to what presents a likelihood of confusion in the mind of a consumer. Consumers don't expect, furniture retailers or furniture companies to sell apparel, right? And so there's no way that the two are going to be at all linked to the mind of consumer. It's a big country. There's 330 million plus people here. There's lots of trademarks filed every week in the United States, from inside the United States and outside. The real estate's really crowded. But I will say that there's typically a way that you can find a niche in every product and service class to register. You just need to be aware of which different categories you need to be searching when you do your trademark research. So that would be something that you could certainly email me about, and I could kind of give you some guidance about where I would be focusing my search if I was working with you.
Awesome. No, that's perfect. So I guess the short answer is, if as long as there's not a confusingly similar mark for the word peachy in whatever you're selling, goods or services wise, yeah, it's likely you can be successful getting a registration.
Yeah, and I guess the last thing I would add to that, JD, is that when we talk about what's confusingly similar from a trademark context, yeah, we're talking about what words, what designs are similar in sight, sound, and meaning. We talk about like that trinity of sight, sound, and meaning a lot in terms of what's a confusingly similar trademark. So your application might be unique in that it uses the word peachy, but is there another meaning for peachy, right? What are the synonyms for peachy, right? If you're spelling it differently, that could be a problem too. So unique spellings don't get us too far at the USPTO either. So we got to take a look at the whole picture and make sure that the application is truly unique in the context of the product or the service.
Yep, absolutely. Yeah, things coming to mind are, let's just say Peachy from like the Mario group, right? The Princess Peach, or who knows what, you got things shaped like peaches. Yeah, anything. So yeah, that's a lot to look at. And
yeah, peachy. I think rosy. Like something's peachy, it's rosy. So those are all different, elements of what you'd want to be researching. You can't just research peachy in that particular class and cross your fingers. It's a little bit more than that.
Matt, awesome. Well, thank you for any of you might have missed it. Look at we got Matt's contact information right there to reach out to him specifically if you have anything. I've got my info there as well for the patent side. We're going to wrap up, folks. So again, we're going to be here every Wednesday, 9 a.m. Pacific, noon on the East Coast, talking patents and trademarks. So thanks again for your time, and have a good rest of your day. Go big, go bold.
Thanks, JD.